Let's take it back live now to those pre-trial proceedings in the corruption case against suspended ANC Secretary-General Ace Magashule and his 15 co-accused. Let's take it back there live.
I addressed a letter to the State's office requesting the process that we need to follow in order for them to provide us with a complete I only got information from Advocate Inez on the 10th of June when the matter was postponed till today, that we needed to provide them with a hard drive. I undertook, which I even handed over it to the offices on the 10th of June. Again, I sent an email to Advocate Inez directly in August, in which I wanted him to confirm if the hard drive is ready for collection so that I can print the documents, take instructions, and also prepare. My Lord, the sad reality of the matter is that on behalf of accused number 2, apparently there's a 212B response which was filed by the previous attorneys of the court. But in terms of the information and when I got appointed as a legal representative for case number 2, I've never even seen if that 212B response is in line with the instructions which he has given me. So I have not even filed any 212B in terms of this matter. And even when we look at the procedures of court, my Lord, Advocate Nathan and all the legal representatives in this matter, they know the 20th of January, even if we can consent to that date, it's not even enough. When you look at the processes at the Supreme Court of Appeal, currently they are on recess for 2 weeks. They're only going to come back on the second week of October. Again, they also have a role which has already been arranged in that court. The fourth term, again, they also have a role which has been arranged. Even if we can come back on the 20th, the pretrial will never be ready. Even the accused, well within their rights that they want to petition, that matter can never be disposed of before the 20th of January. Again, we'll still be forced to come to court on the 20th of January for purposes of a pretrial in this matter, for this matter again to be postponed to a later date which will still have to be agreed to between the parties. Which places accused number 2 in a predicament. My Lord, again, I've also been instructed to even place this on record. It's not even a matter that accused number 2 has intention of hiding it to the Honorable Court. Financially, he's been prejudiced. I have instructions to even bring an application for financial assistance against the very same department which has even placed him on suspension because they refused to cover for the legal fees, which again is a separate matter. Even if, my Lord, that matter can be filed, if that financial application has not been finalized, it means accused number 2 would still have to come to court and request postponement for this trial not to proceed up until that financial application has then been disposed of, which again brings a delay in this matter. My Lord, if the state can consider removing this matter on the road, there won't be prejudice in any event. They have all the personal particulars of all the cases in this matter. If they are still investigating any other point in this matter, surely they can still place it and provide that to the legal representatives of the accused persons in the event that they would decide to place the matter. However, if the matter is not removed, all the accused, including accused number 2, they are definitely prejudiced. I don't know their financial capabilities, but surely, my Lord, matters of this nature is very costly. Only for accused number 2, it has been a costly exercise. Because if you look from the time I got involved in this matter, on the 7th of February 2022, till to date, there's nothing which has been done by myself in this matter. Safe to say that I only appear in court and request and confirm the postponement. But in terms of putting motion into this car, I've never done anything. Maybe for the benefit of other legal representatives who have started with this matter, some things have been done. But as for case number 2, nothing has been done. Hence my request, my Lord, is that the state can simply remove this matter from the road for the betterment of everyone. Once they are ready, the matter can simply be placed on the road so that the matter can then be possible. But the sad reality is that, my Lord, on the 20th of January, the petition or in-application that some of the accused in this matter wants to file in that court, that application would not have been set down. Even when you look even in terms of the rules of the Supreme Court of Appeal, my Lord, in January, again, they're still on recess. That matter would still have not been placed on the it would still have not even been allocated to the presiding officers who would have to hear the said petition application. Now again, if then the matter is postponed to the 20th of January, what will then be coming to court for? To confirm the inevitable, because we're still going to confirm that the matter would have to be postponed, which we can even foresee, today, my lord. And again, my lord, I don't honestly want to overemphasize the issue of financial implications on behalf of a case number 2, but this matter on its own is very costly.
Yes, Mr. Mogale, but what is the position now? I'm told on the one hand that there is an agreement between the defense and the state that this pre-trial will be postponed to the 20th of January 2023. Now you are arguing to the contrary. Are you for a postponement to that date, or are you against it?
I'm against the postponement, my lord, as per my instructions.
That is your instruction?
Those are my instructions.
Yes.
And again, my lord, as I've already indicated, that my instructions are in line with what I've submitted. And it's a well-known fact, my lord, and practice, that even if this matter can be postponed for a pre-trial, so as to see whether the Supreme Court of Appeal would have finalized or dealt with the petition application on behalf of some of the accused in this matter, the reality is that that application would not even have been allocated. There would still have not been a process that would still have to be complied with in the Supreme Court of Appeal, and that process would not even be completed, even on the 20th or before the 20th of January. So if my client would concede to the postponement of this matter to the 20th of January, it defeats the whole purpose, because it means we'll still have to come to court and confirm what we can see today, that this matter will still be postponed further for a pre-trial.
Thank you,
Mr. My Lord, my application is to request the matter to be removed from the roll. The state is not prejudiced. In fact, they even are afforded enough opportunity to put their house in order, my Lord, so that at least when the matter is placed on the roll, then we can just simply move and arrange trial dates in this matter. As a court basis.
Thank you, Mr. Mogale. Mr. Denison, do you have any reply?
Yes, very shortly, thank you, Your Lordship. Unfortunately for Mr. Mogale, there is an agreement between the state and at least 16 of the accused. So it is unfortunate, as I said, that there will be delays in cases such as these. Mr. Mogale now accepts that this process to the appeal court will not be finalized by the 20th of January. I don't know how you can say that. But the long and short, these matters have to be addressed. And no, the state is not going to remove the matter from the roll as it is.
Thank you, Mr. Denison. Am I correct if I say, and I've looked at the indictment, am I correct in saying that the criminal trial itself has no real chance of being disposed of within a month or two? It's going to be a long trial. Am I correct, or am I wrong?
That is most definitely correct.
Could even take up to a year?
At least.
At least a year?
Yes.
Thank you. Thank you. In this matter, the counsel appearing for the accused and counsel appearing for the state have agreed that this pre-trial hearing is to be postponed to the 20th of January 2023. The reason being that some of the accused want to petition the Supreme Court of Appeal for leave to appeal against the judgment of Naidu J in an earlier application launched by them. The accused referred to in this respect is accused number 2, accused, I'm sorry, it's accused number 3, accused number 3, accused number 4, accused number 11, and accused number 13. Now, when the court was on the brink of postponing the matter to that date for the pre-trial hearing to be held, there was an objection by accused number 13, who expressed his dissatisfaction to the postponement of this proceeding. He says that the trial is politically motivated, and by the postponements, he is excluded from running for the top 6, as it was put by his counsel, Advocate Houders. He also complains about a new indictment, a new docket, and so forth. Furthermore, accused number 2, by mouth of Mr. Mogele, expressed also his dissatisfaction with the postponement because in the main he is financially prejudiced if he have to return to court on the 20th of January. Now, as for the objections raised by these specific 2 accused, the problem is that the main criminal trial in this matter will probably take a long time to finish. It will not be a month or 2. I'm informed by Mr. Denyson appearing for the state that the trial will at least last and continue for a period of 12 months. So any financial prejudice at this point in time is not really affecting, or should not really affect, the financial position of any accused. As for accused number 13, it is so that he is one of the accused who wants to petition the Supreme Court of Appeal, and therefore he is in the same boat as the other accused who wants to appeal to the Supreme Court of Appeal. And that is an issue that has to be finished before the main trial can proceed. For these reasons, the pre-trial proceedings of today are postponed to the 20th of January 2023, and the accused are warned to appear in court again on that day, and their bail is extended for that purpose. Thank you, gentlemen. The court will now adjourn.